Start. In a public interest litigation, unlike traditional dispute resolution mechanism, there is no determination or adjudication of individual rights. Stop. While in the ordinary conventional adjudications, the party structure is merely bipolar and the controversy pertains to the determination of the legal consequences of past events, and the remedy is essentially linked to and limited by the logic of the array of the parties, in a public interest action, the proceedings cut across and transcend these traditional forms and inhibitions. Stop. The compulsion for the judicial innovation of the technique of a public interest action is the constitutional promise of a social and economic transformation to usher in an egalitarian social order and a welfare state. Stop para. The dispute is not comparable to one between private parties, with the result there is no recognition of the status of a dominus litige for any individual or group of the individuals to determine the course or destination of the proceedings, except to the extent recognized and permitted by the court. Stop. The right of those who bring the action on behalf of the others must necessarily be subordinate to the interests of those for whose benefit the action is brought. Stop. The grievance in a public interest action, generally speaking, is about the content and conduct of government action in relation to the constitutional or statutory rights of segments of society, and in certain circumstances the conduct of government policies. Stop. Necessarily, both the party structure and the matters in controversy are sprawling and amorphous, be defined and adjusted or readjusted as the case may be, ad hoc, according as the exigencies of the emerging situations. Stop. The proceedings do not partake of predetermined private law litigation models but are exogenously determined by variations of the theme. Stop para. Though we have in our country, recognized a departure from the strict rule of locus standi as applicable to a person in private action, and broadened and liberalized the rule of standing, and thereby permitted a member of the public, having no personal gain or oblique motive, to approach the court for enforcement of the constitutional or legal rights of socially or economically disadvantaged persons who, on account of their poverty or total ignorance of their fundamental rights, are unable to enter the portals of the courts for judicial redress, yet no precise and inflexible working definition has been evolved in respect of locus standi of an individual seeking judicial remedy, and various activities in the field of PIL. Stop. Probably, stop.